mentioning item number 4 and 5 of part 2. Lordship, if this matter may be taken up next week.
Who is the claimant? Who is the counsel for the claimant? Are they present?
My Lord, we have no objection.
Okay. On the prayer made by the learned counsel for the appellants for adjournment of the matter, which is not objected by the learned counsel for the respondents, this is matter in the next week.
For motion, item number 1.
May I please your lordship? My lord, this is criminal petition for postment of this FIR which was subsequently filed on the same course of action. There are two FIR in this case, and we have filed this petition for postment of this second FIR in the charge sheet. Other similarly situated co-accused had already filed criminal petition number 7 of 2025 and 8 of 2025. Other co-accused in this case. Notice was already issued by this court on 22nd of April.
What was issued?
Notice was already issued in those cases, filed by co-accused in the trial court. They were criminal petition number 7 of 2025 and criminal petition number 8 of 2025.
Notice was issued?
Yes, my lord.
Okay, we'll issue notice here
Yes, my
also.
lord.
Mr. Victor L. Ralte, learned counsel for the petitioner, who has filed the instant application under section 528 of the BNSS, 2023, read with section 438/442 of the BNS, BNSS, okay, 2023, for quashing the impugned first information report dated 29/03/2024 of C and POPS case number 3/2024 under section 408/467/468/470/471/477 capital A/120 capital B of the IPC on the grounds that and FIR was lodged earlier on 20/03/2024, which was registered as Aizol PS case number 96/2024 dated 20/03/2024 under section 408/467/468/34 IPC and charge sheeted under charge sheet number 170/2024 dated 10/07/2024, as well as a supplementary charge sheet dated 22/10/2024, which was made on the basis of the same set of allegation earlier alleged before the Aizol police station by PS case number 96/2024. The learned first of the council submits that since the basis for which the FIRs are registered are the same, the instant application may be allowed for quashing the first information report dated 29/03/2024. Notice first of the new para issue notice to the respondents. Mrs. Mary L. Kiante, learned additional PP, accepts notice on behalf of the state respondents. Notice be issued to the private respondents, is it?
I have to
2 and
take,
3 are?
I'll have to take steps in respect of respondent number 2. But as for the respondent number 3, Mahindra, my lord, they have standing counsel. I have served the copy.
We'll issue notice anyway.
Yes, my
sir.
lord.
Notice be issued to the other respondents, okay, instead of private, other respondents through registered post with AD within 3 working days, returnable by 3 weeks. List after 3 weeks.
Much obliged.
For admission. Item number 2.
Yes.
Please, Your Lordship. Your Lordship, this first appeal has been preferred against the judgment and decree dated 25th of February 2025, whereby the probate application filed by the appellant under section 30 clause 2 of the Mizo Marriage, Divorce and Inheritance of Property Act 2014 was dismissed. Your Lordship, if I am allowed, I may point out certain grounds on which the petition was dismissed.
Yes.
Your Lordship may kindly turn to page number 27. There is a certified, it's in the Roman, first portion of the judgment.
Page number
Page 37.
37.
37, it's written in Roman. First certified copy of the true copy of the judgment.
This is it. 27 is there. Page 30 is
27.
27.
Yes.
Okay, yes.
If I am allowed to read paragraph number 26, it states that in the present case, it is not disputed that Shri Robert Shangdawala was hospitalized to Ebenezer Medical Center on 1st of June 2020 and never returned home alive, and that he has been passed away on 22nd of June 2020. On the basis of the evidence adduced by the applicant, the deceased had executed his last will on 1st of June 2020. On the same date, he was hospitalized in the presence of 2 witnesses. In support of the evidences, the applicant exhibited the alleged will as Exhibit P3 and signature of 2 attesting witnesses as Exhibit P3A and Exhibit P3B, but fails to explain whose signature is Exhibit P3A and Exhibit P3B respectively. Moreover, no one exhibited the alleged signature of the alleged testator Shri Robert Shangdawala so as to prove that he had actually executed his will by attesting his signature and the genuineness of the alleged will. So, Your Lordship, if I am allowed, this finding unfortunately is an incorrect finding of the learned court below. Because if Your Lordship will please kindly turn to page number 10 of the same judgment, where for the cross,
Yes.
this is the cross of plaintiff witness number 2. So at paragraph number 17, if I may read it, I cannot say the exact time I put my signature as Exhibit P3A in Exhibit P3, but it was forenoon. So one of the basic fact, like one of the first ground that it has been failed to identify whose signature it was, which has been mentioned in the operative part of the judgment, that is 28. So this ex facie doesn't hold the field because it has been identified that he is the attesting witness and 3A is the signature of the attesting witness.
Okay. Will issue notice?
Yes, Your Lordship. There are certain other grounds, and
the court had found that the execution of the will was done under suspicious circumstances.
Yes.
Is it?
Your Lordship, that is another ground. There are like various other grounds. The presumption of suspicious circumstances was made on the statement of one sole witness. So that was stated, if I may be allowed to identify. Just a minute. So, Your Lordship, if Your Lordship may kindly turn to page number 11 of the petition memorandum of appeal, where I have laid down the grounds, I may be allowed to read that page number 11. round G. So if I will read the
Yes.
Further, the doubt about the suspicious circumstances surrounding the will was raised by opposite party witness number 1, Sri James Remruata, stating in his examination in chief that on 1st day of June 2020, the deceased Robert Shandawala was not fully possessed of his clear conscience, capable of exercising his free will, and the will purported to have been of Robert Shandawala is not his signature. However, the learned court below has failed to consider the fact that this statement is devoid of any truth, as in his cross-examination, he has himself admitted the fact that he reached the hospital at 1 p.m. exact on the same day when the deceased Robert Shandawala was admitted to the hospital, and has also admitted the fact he was not present when the will dated 1st of June 2020 was executed. So the fact is that the person who is alleging when the will was executed, there was some presumption of suspicious circumstances. He himself was not present at that point of time. And that is merely based on the conjecture that he was, after that part he was admitted, based on that, that presumption was made. So, Your Lordship, there are various other findings and there are various other...
Okay, the parties are, how are they related to the deceased Robert Shandawala? How are they related, the parties?
The parties is the...
Appellant is the?
Yes, the appellant is the wife of the
Okay.
deceased.
Uh-huh. And the respondents are the children.
The problem is that the appellant is the second wife of the deceased and the respondent is the first wife and the two children. So there and last 25, in fact, in the respondent is a retired IS officer, even the pension book, the applicant's name had been himself put by the deceased, the testator.
The name of the wife,
Wife, or present, appellant.
the appellant,
Appellant,
was
yes.
reflected in the pension book.
Yes,
For how many years were they married?
they were married, they have been living together since 1993. And there are actually ample amount of evidences which has not been actually substantiated. So, Your Lordship, along with this petition,
So in the will,
yes, Your Lordship,
which was dismissed, all the property was in the name of the appellant or what?
no, in the name of the deceased, yes, it was the legatee is the appellant. All the properties has been given, executed
To
in the
the
name of the
appellant.
appellant.
In the will.
Yeah, yes, Your Lordship.
So it's been challenged by the first wife and the children.
First wife and the children.
Okay, we'll issue notice. Let's see what do they
Your
have to
Lordship,
say.
if I may be allowed, along with this petition, I have filed an IA, that is 19 of 2025, under Order 41, Rule 27 of CPC, to bring on additional evidence.
We'll issue notice
You
for
will-
both
if
of
a
them.
notice may be issued on that.
Yes, heard Mr.
G.R. Datta, Gaurav.
G.R. Datta, learned counsel for the appellant, who has filed the instant appeal under Section 96 of the Code of Civil Procedure Code against the judgment and decree dated 25/02/2025, passed in probate case number 09/2020 by the learned civil judge within brackets senior division close bracket -2, Aizawl, whereby the probate application filed by the appellant / applicant was dismissed and disposed of. Full stop. New para. The learned counsel for the appellant submits that there are sufficient grounds for setting aside the dismissal order by stating that the learned trial court had failed to appreciate the evidence adduced by the parties in its proper perspective. We'll just make it simple. Okay. Appeal is admitted. New para. Appeal is admitted. Issue notice to the respondents through registered post with AD within 3 working days.
Your Lordship, 1 week time may be given.
Okay, within 1 week. Okay. Returnable by 3 weeks. List after 3 weeks.
Your Lordship,
Now in the IA, yes.
if a date may be fixed,
list after 3 weeks on her. When do you want a date? You give a date. On 3 weeks, any date, just mention.
24th of June.
Okay, 24th June, 24/06/2025. Now, in the IA, heard Mr. So-and-so, learned counsel for the applicant slash appellant who has filed the instant application under section 107 within brackets 1, close bracket, then again within brackets small d, read with order 41, Rule 27, and Section 151 of the Court of Civil Procedure Code for production of additional evidence in the connected RFA number 19/2025. What are the grounds? Why additional evidence? They were not available with you at the
Yes,
time of
Your
the-
Lordship, certain documents, because one of the document pertains to the year of 1994. So that document, actually, there are a lot of official papers. So I was aware of the documents, but after due diligence, I was not able to find them. But recently, it came to my finding, the divorce letter which was sent.
Okay,
And-
the learned counsel for the applicant slash appellant submits that the documents mentioned in the instant IA could not be produced before the learned trial court, since the applicant could not procure them while the matter was being heard before the learned trial court. Stop. Again, issue notice to the respondent, same, okay? Same as RFA. And then list on the same date. Yes.
Deeply obliged. But
Item 3.
Yes.
Yes, Your Lordship, in this matter, the state have taken positive steps. In fact, the appointment for Group D and C is already published. However, there is one candidate who did not clear the typing test and yet to do the re-typing test again. And with regards to Group A and B, the matter is still with the MPSC for approval.
Then we'll have to still wait for some time. Steps have been taken, isn't
Steps,
it? What is the MPSC doing? They have to again call what, advertisement?
No, my lord.
No, my lord.
Then what,
DPC.
MPSC?
For
Okay,
DPC.
DPC has to be called for.
When Your Lordship is fixing a short date, they are taking prompt steps, active steps. So if short date may be given.
Your
Anyway,
Lordship,
I think you file your show cause reply now in a form of a affidavit.
Your Lordship, we have
Instead of
already
verbal,
filed.
have you filed an affidavit regarding the steps that have been
No,
taken?
not the present steps.
Huh.
Your Lordship, the fact is that, in fact, there is no contempt in the case. No contempt lies as of now, because the state is taking.
So instead of a verbal submission,
Yes.
show what are the steps taken, where is it still pending? Okay. Then we can see. So now you're simply saying steps are taken, but there is no affidavit to that effect.
Your Lordship,
some
till-
order showing that the DPC is awaited something, some documents.
We
to
have
show
already
that what
filed.
are the
We
steps
have already
taken.
filed to that
Where is
effect.
that?
It's the affidavit filed, additional show cause affidavit filed on 2/4/2025.
Okay, where's that? That's quite recent.
My
Yes.
lord, the latest development which my learned friend submitted happens to be on last week. And that
Yes.
doesn't appear to be on report.
Okay, so the latest development you filed by form of a written affidavit, so that everything is on record
Yes.
in a written form as to the steps that have been taken, isn't it? Yes, Mr. Victor L. Ralte, learned counsel for the petitioner, is present along with Mrs. Mary L. Chiante, learned counsel for the respondents. Full stop. The learned counsel for the respondents submits that the respondents are taking the necessary steps for compliance of the judgment and order of this court in WPC number what?
123, 123,
123 slash
2021,
2021 dated?
17-3,
Yes, it's here, 17/03/2022. And pray that he may be allowed to file an affidavit regarding the present status of the steps taken by the respondents. Praise aloud. List after.
3
week.
weeks, 3 weeks, Your Lordship.
1 week, madam.
In 1 week, nothing will happen. 3
But
weeks.
then- this is judgment of 2022,
no,
madam.
then maybe the affidavit he files will be also be
Yes,
a little
will be
bit
in
more
compliance.
this thing, okay?
2
list
weeks, my lord.
after. Make it
3
3
weeks,
weeks, then let's see. After 3 weeks, something positive should come out. Okay, list after 3 weeks.
Date may be
Obliged.
fixed, madam. Date may be fixed.
On a date.
Yes, madam.
uh,
23rd,
on, list after 3 weeks on.
23rd June.
26th of June.
Okay, 26/6/2025.
Deeply
Yes.
obliged.
Item 4.
Lords, this is for
Yes.
admission hearing. Either, my lords, we can take this up at the end of the board, or my lords, we can take it up now. We are both, parties are both ready.
Okay, we'll make a chambing matter later.
Item 5.
Your Lordship, the delay is, in the matter is condoned. Now the matter,
Yes, so the required amount is deposited?
it's deposited.
Yes. So delay is condoned, it appears. Then, after the condonation of the delay, what is the RFA? Okay, notice is yet to be issued.
Yes, notice is yet to be issued
RFA.
today.
Okay. What is this appeal? Against what judgment? Why?
This is an appeal against the judgment and order of the learned senior civil judge 3, wherein the state state appellant were directed to pay a rental amount to the respondents, and to
Of how much? We were supposed to pay how much?
we were supposed
1,15,000.
no, Your Lordship.
Okay, 1,15,000
Rental compensation with
was
effect
already
from
paid. Is
yes,
it? Oh,
with
okay.
effect from January 1984 at the relevant rate in charge.
Okay, let's see the operative part of the judgment. Where is that?
It's in Roman number 21, paragraph number 30. Shall I read, Your Lordship?
PG department directed to pay rental compensation.
Yes, to be assessed by the pro forma
Okay,
department.
so it means that his PhD department was occupying his land, I believe, from where? At which place? Where? What?
Dorpui Vengthar.
Will you show notice? Heard Mrs. Mary L. Chiante, learned government advocate for the state appellants, who has filed the instant appeal against, filed the instant appeal under section 17, within brackets 2, within brackets small b of the Mizoram Civil Codes Act, 2005, read with section 96 of the Code of Civil Procedure, against the judgment and order dated 18/03/2020, passed by the learned senior civil judge -3, Aizawl District, Aizawl in civil suit number 11 of 28, wherein
Your Lordship, it's 2008.
2008,
Okay.
wherein the appellants were directed to pay rental compensation to the respondent with effect from January, 1984 at the relevant rate of rental charge within 3 months from the date of the receipt of the order. Full stop. The new para, the learned government advocate submits that ground of appeal.
The ground of appeal is that, Your Lordship, the land was already bought by the PHE
Okay.
department.
By the learned government advocate submits that the said judgment and order dated 18/03/2020 okay, is liable to be set aside since the land said to belong to the respondent was already purchased by the state appellants.
And DPL was already in the name.
And therefore, they were not liable to pay any rent for the occupation of the said land. Full stop. Then new para, appeal is admitted. Issue notice to the respondents, sole respondent, is it? Issue notice to the sole respondent, stop, Mr.
Lobo Maralte.
Duo Maralte, Learned Counsel, accepts notice on behalf of the sole respondent. No need to issue formal notice. Requisite copy of the appeal memo to be duly furnished to the Learned Counsel for the respondent. Yes. LCR required,
Yes, Your Lordship.
TCR to be called for, list after 2 weeks.
Your Lordship, pending disposal of the writ appeal, the RFA, the learned trial court order be
Yes.
state.
On the submission made by the Learned Counsel for the appellant, pending the disposal of the instant RFA, the impugned judgment and order is stayed. Stayed. Okay, just full stop. Yes. Yes. Then list after 3 weeks. We say. Now, before you go, is it required? We have called for the LCR. Is it required in this case?
Yes, Your Lordship, I think paper book will have to be,
It is required. Is it okay?
Item 6.
My lord, I have received the counter affidavit filed by the respondents, and my lord, I will not be filing a rejoinder. So, if this case may be admitted,
Or you want to file rejoinder?
no, my lord, I will not be filing.
Then where's the counsel for the
They are not here.
respondent?
They are not here today,
Then we'll have to fix another date.
my lord.
Mr. Tila Zakima, Learned Counsel for the petitioner is present, while none appeared for the respondents. The Learned Counsel for the petitioner submits that he has received the copy of the counter affidavit and will not be filing his rejoinder affidavit. In view of the above, it appears that pleadings are complete. List the matter for admission hearing in the next date. List after 2 weeks.
My lord, obliged.
Item 7.
May I please, your lordship? I had mentioned this yesterday, my lord.
Yes, what did you
I would
mention?
like to seek for withdrawal with liberty.
Oh, okay. What? What happened?
There is certain development in another case. This court had passed a judgment which is in our favor. So in view of that, I have to improve
Okay.
the petition.
Yes. Mr. Victor L. Ralte, learned counsel for the petitioner, is present, along with Kalman Hui, learned government advocate for the state respondents. The learned counsel for the petitioner submits that he would like to withdraw the instant writ petition
with liberty.
with the liberty to file afresh due to the recent developments in the connected, in the matter. Okay? In the matter itself. Praise aloud. The writ petition number 200 of 2024 stands disposed of on withdrawal with the permission to file afresh if so advised.
Deeply obliged.
Item 8.
Oh, this is a jail appeal.
Yes.
21 Indian PS. This is a jail appeal filed for setting aside the judgment and order in SR number 193/2017, comma, reference excise and narcotic case number N-144/2017 under section 21 within bracket C of the NDNPS Act, wherein the accused was convicted under section 21C of the NDNPS Act on let me just see the judgment. It is not clear. On 30/08/2022 and by the order dated 01/09/2022 was sentenced to undergo rigorous imprisonment for 10 years with a fine of rupees 1 lakh in default RI for 1 year. Issue notice to the respondent, state respondent. Then Mrs. Mary L. Kiante, learned additional PP, accepts notice on behalf of the state respondent. The documents enclosed, the appeal petition along with all documents enclosed to be duly furnished to the learned additional PP. Full stop. Registry to appoint an amicus curiae to represent the appellant. Full stop. Then TCR to be called for. List after 3 weeks.
Item 9.
Your Lordship, I believe that the notice on respondent number 2 have to be issued.
This is under NDNPS.
No, my lord.
Boxer.
Boxo. Okay, I thought previous one was NDNPS.
Yes.
Yes. Then a notice be issued to respondent.
Your Lordship, this is a bail application from jail.
Now, this, I have looked through it. The reason why they have filed the bail application is on medical grounds.
Okay.
So I think the additional PP will find out about the status of the applicant, and also see whether it will be appropriate in such cases to appoint an amicus curiae or not. You just see. In the meantime, you see whether there's any urgency in the matter and what is his health status.
Yes, Your Lordship, if a copy of the bail
Yes,
application
yes.
be,
This is an application filed from jail by the accused, who is detained in the policy jail in connection with EX KLB PS case number 5/2025 under section 21 within bracket C NDNPS Act, on the grounds that the applicant is suffering from acute medical problems and has therefore applied for bail, since his bail application was rejected by the Judge Fast Track Court, Policy District, Policy, Policy, Okay, I said policy, full stop, instead of policy, in bail application number 20 of 2025, dated 19/05/2025. Stop. Then, new para, this court, considering the fact that the grounds for the application of bail is due to acute medical problems, find it fit that the learned additional PP, Mrs. Mary L. Kianke, should take necessary steps to inquire about the health condition of the applicant, and also look into the feasibility of appointing an amicus curiae to represent the applicant in such cases. List after, how long will it take?
since it concerns with the health,
List on, let's fix a date.
Tuesday, Wednesday?
It's in Colosseum. Okay, so
Yes.
you'll have to contact the superintendent, Colosseum,
Yes.
and all that. Wednesday is a DB day. I don't know how busy we will be. We'll make it Thursday. Will you be ready by 3rd June, Tuesday?
Yes.
You'll get some information by Tuesday, 3rd June.
Attempt will be made, yes. Endeavor will be made.
Okay, list on 3/6/2025.
Oblige.
Item 12.
Yes.
Lordship, this is an application for implement of
Oh, yes. In treatment of one person,
one person,
saying that,
Okay.
okay, yes,
Srimati Jubilee Ichoa, as respondent number 5A, in view of the fact that she is continuing construction of a building within the land in dispute, and on perusal of the reports, it is found that the LSC of the respondent number 5 had already been transferred in the name of the said opposite party sought to be pleaded. So, Your Lordship, this application has been necessitated in view of the fact that earlier the applicants who are the appellants herein have filed an application for temporary injunction so as to direct her not to continue with the construction.
Okay, but this person who you want to implead right now, why was she not made a party in the previous, civil suit?
Civil
or
suit,
what?
she was not made a
civil-
party. She was not made a party because it is the respondent number 5 who had represented her all through the
Okay.
proceedings of the civil suit. So, the respondent number 5 never hinted that Srimati Jubilee Chauhan will be taking over the responsibility. Instead, he had taken all responsibility in challenging the LSCs of the appellants. So, in that view of the matter, the Honorable, the Dalat lower court.
So the
Dalat lower
respondent, let me just make it, so the respondent was the plaintiff in the civil suit, is it?
Yes, yes.
Okay,
Respondent number 5
was the plaintiff in the
Plaintiff.
civil suit, and therefore, okay, fine. Yes, so we
And-
continue with the IE.
Lordship, this application has been necessitated because of the fact that when the connected civil IA 65 of 2025 was filed and moved for interim injunction against Srimati Jubilee Chauhan. The Honorable Court, this Honorable Court was of the view that since she is not a party, no effective order can be passed. So, as a result, we had filed the instant application so that the application may be allowed, she may be pleaded as a respondent number 5, and then she will be bound by the order, whatever order that may be passed by this Honorable Court, and directing her not to continue with the construction of the building which is on the suit land. In this connection, Your Lordship, since this 76 of 2025 IA civil number 76 of 2025 is also connected Your Lordship permits that the facts necessitating filing of this IAS Civil number 76 of 2025 may also be placed before Your Lordship.
Yes. This is the injunction order.
Injunction.
Pray
yes,
for an
application.
injunction order.
Yes,
Yes.
application for order. Under Order 39, Rule 1, read with Section 151 CPC for grant of interim injunction against Srimati Jubilee Ijwa, directing her to discontinue construction of the building structure within the land covered by LSC number 104703001/1099 of 2010, belonging to the applicant, appellant number 1, during the pendency of the appeal. If I take a Lordship
So
to,
let's dispose of the infringement application first then. No? Yes. So that's it. Then we'll hear the opposite party
Your Lordship,
for the infringement. Can we hear the respondents?
yes, yes.
They have filed the objection, so let's hear them. Yes. What is the objection?
My lord, I have submitted in the affidavit and I
Yes. What is it?
have reflected in para number 3, that is in page number 5, my lord. If I may read out. My lord, that we would like to state that the present application is not maintainable in its present form and style and is liable to be dismissed. The application is made under Order 1, Rule 10, Clause 2, read with 151 of CPC. It is humbly submitted that on careful perusal of Order 1, Rule 10, it is mandatory for adding new party that she may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit. Perusal of the said provisions specified impleadment of parties in the suit, but no appeal, and hence the present case being an appeal could not attract Order 1, Rule 10, Clause 2 of CPC for impleadment of the parties. Presuming, but not admitting that the said provision is applicable in appeal, it is necessary that the proposed party be necessary for the court to adjudicate upon and settle questions involved in the suit. Hence, it is necessary to consider what questions involved in the suit appeal. In the appeal, the applicants herein raised as many as 8 numbers of grounds, but none of such grounds specified the necessity of impleadment of the proposed new party, as there is a total absence of question which may be involved in the proposed new party. With the appeal such being the situation, the present application being bad in law is liable to be dismissed. Therefore, that even presuming but not admitting the impleadment as prayed by the applicants is granted, it does not end up the arbitrariness of the appeal, as the present application, being a part of the RFA number 1 of 2025, is to be examined with its relevancy and connection with the main appeal. It is humbly submitted herein that in the main appeal, there are 5 number of respondents, out of which 3 respondents, such as respondent number 1, 3, and 5, have no more legitimate interest in the present case. Respondent number 1, LSC number 626 of 2005, that is in page number 37 of Memo of Appeal, was already purchased by He-Pei late, even prior to filing the original suit, and the same was mutated in his name. From information, Sri He-Pei was also passed away in the year 2022, and there might also be some legal heirship certificate in respect of landed property previously held by the respondent opposite number OP number 1. Respondent number 2 is also no longer owner of 628 of 2005. That is in page number 44 of Memo of Appeal, already mutated in the name of Srimati Lalmonpui Pachuao in December 2014. Likewise, the respondent number 5 also has no interest in the case, as the LSC number 625 of 2005 was already mutated in the name of Srimati Jubilee Ijwa. That is in page number 47 of Memo of Appeal. All such facts are found from Memo of Appeal, and in fact, the applicants or the appellants as of now could have legitimate claim upon respondent number 2 and 4 only. Considering all such nature, it is clear that the mere impleadment of Srimati Jubilee Ijwa as one of the respondent in the main appeal could have no value in the appeal. Further, from perusal of memo of appeal, the applicants did not make any prayer which may be connected with a temporary injunction, if any, against the respondent OPs, and hence the present application, being lack of reasonableness, is liable to be dismissed. My lord, if I may take you to para number 6, that with regard to paragraph number 3 of the application, the answering respondent 1 to 5 would like to submit that the judgment and order dated 17 October 2024 passed in the connected civil suit has been passed after due consideration of evidence and legal submission of both parties. Therefore, the applicants seeking impleadment of respondent number 5A solely on the ground that the property in dispute, that is LSC number 625 of 2005, has been purchased by her from respondent number 5. The applicants' appellants have not shown any substantial ground or irreparable injury or urgent circumstances warranting to implead respondent number 5A. More so, the application does not establish the proposed party has a direct or substantial interest in the subject matter of the dispute. Mere reference to a photograph or picture without further substantiation does not fulfill the legal requirements for impleadment, and that the allegation that is necessary in order to enable the Honorable Court effectually and completely to adjudicate upon and settle all the questions involved in the connected RFA 1 of 2025 does not establish a sufficient nexus between the proposed party. Therefore, it is respectfully submitted that the application lack legal validity, hence the application be dismissed. That is, my lord, that is the affidavit which I have submitted, and that is the submission which I would like to give.
Okay, let's look at Order 1, Rule 10, CPC. What does it say?
My lord, if I may read out.
Yes, wait.
Order.
The application is made under Order 1, Rule 10.
Yes, ma'am.
So you're saying that under Order 1, Rule 10, when an impleadment application is made, it should be done while the matter was being tried before the learned trial court,
Yes,
not in the stage of the appeal.
Yes, ma'am.
That's your point, isn't
Yes, ma'am.
it? So let's see.
My lord, I may read out
Where's Order 1, Rule 10?
those two.
Which one, Joe? God says. Yes, okay. Now,
The court may at any stage of the proceedings, either upon or without the application of either party, and on such terms as may appear to the court to be just, order that the name of any party improperly joined, whether as plaintiff or defendant, be struck out, and that the name of any person who ought to have been joined, whether as plaintiff or defendant, or whose presence before the court may be necessary in order to enable the court effectually and completely to adjudicate upon and settle all the questions involved in the suit be added. My lord, the questions involved in the suit, in this particular instance suit, my lord. So, as per the provisions, the questions which is involved was not raised in the main memo of appeal, my lord. And as I've mentioned in the affidavit, my lord.
but in the appeal, in
Yes.
the RFA,
Yes, my lord.
in the RFA, her name was mentioned
Her name was not mentioned, my lord.
in the RFA.
No, my lord. Even in the grounds, there are 8 number of grounds, my lord. There is no mentioning of such impleadments or necessity of impleadment of Miss Jubilee or any other respondents, my lord.
Now, in the instant IA, it is for the impleadment in the RFA or what? The IA is for impleadment of
Yes, Your Lordship.
Jubilee in the RFA, is it?
RFA as respondent number 5A.
Okay, in the RFA.
Yes.
So when the matter was tried before the trial court, and the respondents were the plaintiffs. The defendants did not know that the landed property was purchased by the present person you want to implead, Ms. Jubilee.
Lordship,
Mrs.
the fact
Jubilee,
is like this. In the year 2014, a suit was filed. And when WS was filed by the
By you,
appellants,
the appellants,
by the appellants, no such thing was there.
Okay.
And subsequently, in the year 2021, on the basis of a recast petition, a recast plaint, all such documents had come into existence. So those documents were brought into existence in connection with the plaint, or on the basis of application made by the respondents, that is the plaintiffs. And even at that point of time, they continue to pursue the case as if it were their own interest. They never said, even once, that the
Okay,
defendant,
that it was sold to Jubilee.
it was sold to Jubilee, and that they did not have any more interest over the suit land. They continue to pressurize upon the landed court till the end, and the decree was passed against the defendants who are the appellants herein. And now, if it is the submission of the Learned Council that since the respondent number 1, 2, and 5 are no longer interested, and
Then it's good for you.
then it
It's
can be
good for you in
declared.
the appeal.
It can be declared
Huh.
that the decree, so far as they are concerned, is a nullity.
Anyways, so the main thing is whether to implead Jubilee or not, isn't it?
Yes.
So you have also filed this application under 151.
Yes.
CPC.
151 CPC.
Okay.
And also-
Considering the fact that the disputed property
yes.
is now in the hands of Jubilee and she's making construction.
Yes.
She's doing certain constructions. And therefore, I think in the interest of justice, she has to be included
My lord,
that's,
under 151
only submission.
CPC.
My lord, if I may,
And then
On-
we'll look at the rest of that
Yes, ma'am.
later. Because
There is
now since they are disputing over the said property where she's constructing the building, and supposing if later the judgment and order of the learned trial court is set aside, then what will happen if Jubilee is still constructing the building? So the dispute is over the landed property, isn't it? Where Jubilee is constructing the
Yes.
house. So you have to use your common sense also sometimes, not so technical. 151. Then what will happen? That's my main concern. If she's allowed to continue. So I think in the interest of justice, we'll have to make her stop for some time. Because if, I don't know, we have to look into the merits. I don't know anything about the merits of the case. But since they're saying that the dispute is over the said landed property where Jubilee is constructing the house, then unless we stop her from constructing the house, and supposing the appeal is allowed, then it will be Jubilee who will also be facing some loss if she's also not made aware as to what is going on, isn't it? So I think it is appropriate to implead her then. Whatever happened before the trial court where you had not mentioned that Jubilee had purchased the land, etc., that should have been done. But since it's not done and it's on the appellate stage, we'll have to see. I mean, just looking at it from your submission, it appears that she has to be also involved. So we'll exercise the power under her.
And
Already
that's
issued.
yes. That's the
Without
service
her
was
being
also-
impleaded, notice was also issued to her.
Lordship, in connection with this IA, irrespective of whether it was, impleadment was made or not, she was given
Notice
notice.
was already issued.
Yes.
Then, anyways, so now that she is formally impleaded, okay, we'll issue fresh notice to her and inform her. What? Notice was issued through Dusty? Did she receive notice? Anything
Yes,
like
Your
that?
Lordship. On 19/5. 19/5,
But I think since now she's officially or formally impleaded, I'll pass the order. Okay, we'll issue fresh notice to her, give her one more chance if she has anything to say. If she doesn't have to say, then we'll have to hear the matter. What about the other respondents? Have you filed your written objection in the IA 76?
No, my lord.
So we'll give you a chance also to file a written objection.
Yes, my lord.
Okay. Now, IA 77, I'll pass the order later. Okay. Disposed of, allowed, disposed. This IA 77. Now, in IA 76, on the disposal of IA 77/2025, wherein Srimati Jubilee E. Chauha is allowed to be impleaded in the connected RFA number 1 of 2025 as respondent number
5A.
5A. Issue notice. 5A. This court find it fit that he should also be impleaded in the connected IA number 76/2025. Heard Mr. C. Ramzawa, learned senior counsel, assisted by Mr. J. Malsom Zola, is it? Learned counsel, wherein the learned counsel submits that the application filed under 39, Order 39, Rule 1, read with Section 151 CPC, is to grant interim injunction against the impleaded Srimati Jubilee E. Chauhan for an order against her to discontinue construction of the building / structure within the land covered under LSC number 104703/01/1099/ which is said to belong to the applicant / appellant. Number 1, during the pendency of the connected RFA number 1/2025. Notice be issued to the respondents, Mr. J.H. Vicky so-and-so, accepts notice on behalf of respondent number
1 to 5.
1 to 5.
There are only 2 respondents here in this connected application.
In the IA,
In the IA.
On behalf
Srimati.
of respondent number 2, is it?
Respondent.
Are you 2, Laldong Liana?
Yes, madam.
Respondent number 2. Notice be issued through registered post with AB within 3 working days, returnable by 2 weeks.
Your Lordship will make dusty service And
Okay.
if it can be taken up within a short time, because in the meantime, if construction goes
Okay,
on,
2 weeks. Construction in this weather will not go on. Within 2 weeks.
let it be within the next Friday. 1 week, Your Lordship.
Okay, returnable within 1 week. The Learned Counsel for the applicant has also expressed urgency in the matter. In view of the above, he is also allowed to take steps for service of notice upon respondent number 1 through dusty mode. Affidavit to that effect to be duly filed. List
The next
after
Friday.
1 week on, give me a date,
6 June.
6 June, 6/6/2025.
Yes.
Yes.
Your Lordship, in RFA number 1 of 2025, we'll have to
In the main RFA, on the disposal of IA 77/2025, including 25, comma, the Learned Counsel for the appellant is to take necessary steps for making correction in the cause title, reflecting the name of the newly pleaded respondent number 5A.
Your Lordship.
Thereafter, notice be issued to the newly impeded respondent number 5A, Mr. Ricky so-and-so, Learned Counsel for respondents number 1 to
1 to
5.
5, my lord.
5 is present. Yes, then list this said RF list along with the connected IA number 76/2025. Yes.
God bless.
Obliged, my lord.
Item 4.
Yes.
I'm appearing for the petitioner in this case.
This is admission hearing, only for admission, isn't it?
My lords, we are seeking a hearing, my lords, any hearing on this. My lords, there's a small reason for this, is that, my lords, the charged officer, the petitioner, her DPC is coming up, my lords. And if your lordship sets it aside, the impugned order, she may be in the zone of consideration.
No, DPC, they can continue.
My lords, she'll lose her chance to be promoted. And my lords, my submissions will be very brief, along with judgments.
See, we'll admit your this thing, WPC, let's list it for hearing. We'll give it a short date.
My lords, in the next week, if possible.
Let's admit it first, okay? Instead of disposing of in the admission stage, it won't be appropriate. Yes.
My lords,
Yes, heard Mr. Jordan Roming Thanga, Learned Counsel for the petitioner, along with Ms. Lal Nunthui, Learned Government Advocate for the state respondents. On hearing the submissions made by the Learned Counsels, appeal is admitted. List for hearing on, yes, now give me a
sixth,
date.
my lords, 6th.
Okay, 6/6/2025.
6th of June, Your Lordship.
Yes, 6/6, so that at least I get to read through.
Yes, ma'am.
Yes, Your Lordship.
Part 2, item number 6.
None appeared for the, let's see how many times have they been called. If the parties do not represent them for 3, last court date were they present? They were present. None appeared before the parties on call. List after 2 weeks.
Item 10.
How many times is there non-appearance? None appeared for the parties on call. List after 3 weeks.